Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 59, Praying at the Bar. Hello, welcome back to This Week in Law with Denise Howell. This is episode 59. We're here today on May 7th, 2010, recording live at live.twit.tv. We're here today with Kevin Thompson of Cyber Law Central at Cyber Law on Twitter. Hi, Kevin. Great to have you on the show.
Hey, Denise. Thanks for having me.
My pleasure. Also with us is Marty Schwimmer, the trademark blogger. Hi, Marty. Great to have you back.
Good to see you again, Denise.
You can find Marty at the trademark law blog, schwimmerlegal.com, and at mschwimmer on Twitter. And joining us once again, Evan Brown. Evan, hi.
Hi, Denise. It's great to be here, as always. Thanks for having me.
Great to have you back. You can find Evan at internetcases.com and follow him at internetcases on Twitter. So, guys, I wanted to get into, first off the bat today, all the stuff that's been raining down about Facebook and see if we can make some sense about where things stand with the mother of all social networks on the privacy front right now. Facebook recently made some changes to its settings where it is opening up some information to third-party sites that has not been shared in quite this way before. The goal is to make users' experiences on those sites more personal, to incorporate their social graph, their social network, information from their friends into the experience they have on sites like Pandora, where they can now go, and if they have opted to share their Facebook information with Pandora, they will have an experience where they hear, for example, some of their friends' music or their friends' music selections over there, and similar kinds of personalizations on other sites. But there has been all kinds of confusion about the settings for this new kind of strategy, and also various concerns about privacy at Facebook in general, and to the effect where now Washington is beginning to get involved and make noises about coming in and regulating not just Facebook, but the whole world of sharing user information online. So with that said, let's talk first about this new game plan at Facebook. And Kevin, let's start with you. What is your take on it? Do you think that it is out of whack with user expectations or what a social network should be doing with user data?
Well, I certainly think that the Facebook settings are definitely changing over time. When I personally first signed up with Facebook, it was a much more in line with your normal expectations that you've got a private group that you are friends with, and you only use it to go out and talk with your friends. You let them know what you're doing. You're posting links to what you're up to. People comment, so forth. Now, with the way these settings work with the personalizations, what you're seeing is what people are doing on other sites as well. It's if you happen to be signed into your Facebook page, when you visit, for example, CNN, you'll see articles that your friends have recommended, articles that your friends have shared on CNN while they themselves were signed into their Facebook page. And I certainly think that that is a little bit out of line with what people were originally expecting when they signed up for Facebook.
Right. And Evan, what do you think about Facebook's recent move to change information such as your hometown, education, work history, interests, etc., into connections that give more people access to that information unless you go and specifically opt out?
And now that we're a few years into Facebook, we're just able to, for the first time, ascertain that this is just a trend probably that has been in their mind ever since the beginning. And this trend gives rise to this tension that we've always known about when we talk about data privacy, is that the usefulness of information and the privacy of that information are inversely proportional with one another. The more you anonymize data or make it unavailable, the less utility it's going to have. And of course, Facebook, with its commercial incentive for there to be openness and connection and sharing here, is more on favor of it being open and moving away from privacy. And it perhaps is post hoc, which is a term we've thrown around on this show before. After the fact, going back and looking at it, this saying, oh well, everybody wants their information to be open anyway. So with connections here, this just seems to me to be a natural evolution, next step in the evolution here of what's going on with Facebook, all the way, starting back relatively early on with Beacon and then going into the privacy brouhaha that we saw in February of 2009 with them claiming a very overexpansive license on intellectual property and rights of publicity. So it reminds me of a quote that I saw recently in a different context. It was at the health club when I was on the treadmill, but one of the things that flashed across the screen was, you don't know how far to go unless you go too far. Mm-hmm. And that might be one of those things that might be one of the impulses that Facebook is operating on here. So far, as far as I can tell, I haven't been watching the data closely, but Facebook adoption still seems to be increasing. The big number that everybody's throwing around, more than 400 million users. It'd be the third largest country on the face of the planet. These are all facts that we know by heart now. So until there really is a market effect, I think we could just expect Facebook. A market effect, in the form of a user backlash, people actually deleting their accounts and going away. Facebook will just continue to open things up here for the sake of greater utility and the ability to connect its users. So I don't expect anything to change until they've gone too far.
Right. And just to clarify that this third-party sharing aspect is not, it interplays with connections, but it's not exactly the same thing. Am I understanding that properly? That connections affects the kind of information that you're not just sharing with third parties, but also among all of the Facebook users. But there's certain information that used to be more subject to your privacy settings that is now made open unless you go ahead and lock that down.
Exactly. Connections is more of a notion now rather than this information being a predicate about you, like, where you're from or what books you like or what movies you like. Now these are devices, rather than just being descriptions of you, there are now devices that connect you with other users. And it's one of those things where you can no longer provide that information now about yourself unless you permit it to be a bit of information that connects you with other users and makes you available for being found. You can't just as easily declare facts about yourself now. It's now, truly inherently a part of the social graph rather than it just being something, a data point that one can search on. So that's really the fundamental difference, I think, now with the connections and what gives the biggest concern from a privacy standpoint. Right.
So it seems like an expansion of the strategy Facebook had years ago where they encouraged you to join a local network of people that were in your geographic region, but that you did not know personally necessarily, and your information, certain information, would be shared with those people by default, unless you opted out of that network altogether. So
right, looking back on it, that seems pretty harmless now, doesn't it?
Right.
And it's probably pretty easy for us to sit here and, or at least I've said it, assign to Facebook some kind of Dr. Evil kind of mentality on this, always, looking to slowly creep up and eventually take over the world in terms of lack of privacy. But, it's probably just as likely to say that Facebook, when Mark Zuckerberg was in his dorm room in 2003, was that when it was, 2002, 2003, he probably didn't have a plan to take over the world. I'm sure he wanted to develop something that was successful, but I think
he wanted to meet women.
Well, that's, that's funny how that can motivate people. that's just one of those things that looking back on it now, it's easier to look at this being a whole big bad nefarious effort, which is probably not exactly accurate.
Mm-hmm. So, Marty, what's your take on this? And you were telling me this morning when we tested your Skype something personal that happened in your family regarding this.
Well, I want to agree with what you said about there being a disconnect between user expectations and what Facebook is doing. And I think that has to do mostly with the fact that they have a long way to go with usability, enhancing usability, so you know exactly how this thing works. I find myself asking my wife consistently, wait, this photo, who can see this? And why am I capable of seeing what my friends are saying? So I think that they're changing these rules. I don't think they do the most fantastic job in explaining what you can see, what you can show, how to adjust these settings. So there's an awful lot of, in theory, I do this for a living, and I find that I can't keep up to date with who sees what and what I can do. I went on to CNN.com last week, pretty much the first day of that open graph was being activated, and I see my friend's name on CNN.com that she had liked a certain article, and my immediate reaction was, why is my friend being quoted on CNN.com? And then I looked forward and I realized that it's the open graph, but my initial reaction was, it was a little creepy. And also my initial reaction was, how does CNN.com know that this person is my friend? Which seemed to me to be a little bit of an invasion of privacy, which is incorrect because I tell everyone on Facebook who my friends are. And I blogged about it and asked people how this worked, and someone explained to me that CNN.com doesn't know at all who your friends are, that Facebook is populating that box. So I think there's a little bit of a black box aspect to how Facebook is operating, how the open graph system works, how the privacy settings work. They could do a lot better job in making this a little bit more user-friendly. The story I was telling you had to do more with the world that our children are growing up with that's different from our own expectations. My son had posted as his status that Mrs. So-and-so, who gives him too much homework, sucks, which he spelled S-U-X, I'll note. And one of his friends immediately commented on his status saying, be careful because the principal is monitoring Facebook. And this is because there was some unpleasant incidents during Kick a Ginger Day about 2 months ago. I don't know how many of you know that for some reason someone created a group called Kick a Ginger, which is a derogatory term for an Irish person, and some clever middle school students at my son's school kicked some gingers, which made the principal furious and has subjected them to a series of lectures on don't do everything that Facebook tells you. So since then, they have been monitoring Facebook fairly closely. So I went into my son's room and I explained to him that, when I was his age, I would probably say to someone that Mrs. So-and-so sucked because she gave us too much homework, and it is conceivable that someone would have eavesdropped and told the teacher, and I could have gotten in trouble. And I might have had some sort of justification as to privacy as to what I'm saying, and that his posting that Mrs. So-and-so sucked on Facebook has absolutely no right to privacy, and that this is just the sort of thing. I'm not criticizing him for holding this deeply held belief that his teacher sucked, but that these are the new rules of the road. You're publishing, you're a newspaper. The most trivial thing is going to be in this permanent form of storage. And we're beginning to hear the horror stories of high schools and colleges looking at applicants' Facebook and other social media pages and enforcing this sort of more unfair standard of what is acceptable public discourse.
Well, let's unpack that a little bit, because it seems to me there should be a way. Unless your son is doing his Facebook activities on a school-issued device and the monitoring is happening that way. It seems to me there should be a way that his account is actually, his status updates are made available only to the people he specifies in the settings, and that presumably that wouldn't include the principal or any other administrators at the school. Isn't that right?
Well, yeah, I know you're directing that at Marty, but that would seem right, assuming that the principal isn't impersonating someone else, who the son is friends with.
Yeah, that's true.
Now, do you have any idea how they think the principal is monitoring them?
Your basic point is correct, that in theory you can't just scour Facebook postings of those who you're not friends or friends of friends of. But I know that I've learned an awful lot about my friend's colleagues merely by being in the same room while he's doing it. And all you need is one parent leaning over his shoulder who then tattles.
PIR, parents in the room.
World. Right.
Right. Yeah, no, I mean, definitely there's that leakage point, which wouldn't be something for Facebook to be concerned with in its policies and practices. But yeah, I'm curious as how technically, well, let's talk about this Friends of Friends change, because that's relatively new too. Can someone explain exactly what's happening now and how we're seeing that information now that perhaps we didn't see in the past? Kevin?
Well, I was going to say that there are certain ways you can see your Friends of Friends. For example, I've got a friend whose son has recently started coming online, and I was originally concerned that before I was actually even his friend, I was able to see his wall and his pictures and certain other information that it probably didn't want other people to see. And it turned out I was able to see that because I was friends with that person's parent. And so I was a friend of a friend. But by extension, there are lots of people that I am friends with on Facebook because I only know them from high school or college or some other distant relation. And sure, I want to know what they're up to, but they may or may not want to know what my friend's son is up to, or to see his personal information. And that's sort of what the Friends of a Friend concept is.
So, Evan, if I'm getting this right, this is a setting you can tweak in your privacy settings where you go through each item, for example, your status updates, and decide whether you want that visible only to friends or friends and friends of friends, or on up the line to everybody. Is that how that's now working?
Yes, yes, and I think that was part of the changes they made back in maybe December. I know that's been around for a little while, but it really is one of those things where it's not obvious how what the effects of that setting would be when you because you don't really know who exactly. I mean, there's no way for one conceivably to have an accurate, granular sense of who all of your friends are, and there can be some really obscure connections, just 1 degree of separation there. And your arch enemy or a rival who would set out to do you harm with information that it has about you could very well easily be friends with someone that you don't know, or it's not inconceivable, but that just 1 degree of separation there could be a connection that you wouldn't want to have made. And a certain way of looking at it is it could be that it's much more likely that someone who knows someone would have more of a motive or a desire or an intent or a reason to want to do you harm rather than just some random stranger out there. If it's somebody from your past or just somebody who's disgruntled with you for whatever reason, it's likely that even if you're not friends with them, they're going to be friends with somebody you know. So it's a dangerous setting.
That's a really excellent point to make, and it's worth pointing out that people, because of these different shifts in the way that Facebook has handled data over the years, I think they've landed themselves in a situation where different people approach Facebook differently. You have people who got involved maybe in the very early days where it was a vehicle to simply connect with people you already knew and be able to, in a fine-grained way, share very personal information that you would not otherwise perhaps want on the open web, such as your precise location at a given time, your address, your phone number, and photos of a personal nature, everything that you would share with friends in the real world. And over time, I think Facebook has evolved into more of a public forum, public activity sort of place, but you still, I think, have people who view it both ways. So, as you say, Evan, that's a real opportunity for people's expectations to clash, because you have to go through sort of two steps of analysis if you're going through your privacy settings, and who knows who actually, how many people actually go through and check those settings anyway.
Right.
But when you're thinking of, okay, I'm going to share these with friends, and I know who my friends are, and then I'm going to share perhaps with friends of friends, and that's okay because my friends' friends, why wouldn't they be my friends? Sure. Maybe you're not taking into account that people now use Facebook as though it were the open web.
It's a paradox for one's self because, on one hand, you want to preserve your privacy. And on the other hand, you want to be open and able to connect with people who you want to, who you may want to connect with. I think I just made a tautology, but the people that you're likely going to want to be friends with are already friends with someone else. But at the same time, going back to what I said earlier, and we've been, obviously the tone that we've taken in this conversation is kind of a tale of woe about the state of privacy on Facebook and the way Facebook has been. But I think it's important that we counterbalance our approach on this by examining at least the approach that Chris Pirillo made in a post that was in our show notes for today. He was saying, well, come on. You can always have private information about yourself. You just don't put it on the internet. How's that for a novel thought here? What's the big deal about anyone, even if it being somebody intent on doing you harm, the fact that you like a certain movie? Given setting aside the negative connotations of what, an employer may think if you, really, really like The Hangover. I don't know. That's pretty benign example, So does that mean you're a drunk or whatever? But, setting that aside, there's what really is the big deal here with this information being out there. And I don't want to, answer my own question, but I would submit that probably in each individual piece of information here, there's not all that much harm, but the danger comes from the aggregation of information that may be able to be had about you in the composite bunch of different data sets from or data points forming a larger set out there.
Right.
Yeah, Evan, you may not want to answer your own question, but I'll certainly hop in here if you don't mind. I think that's certainly one problem with this information being out there on Facebook is that people share a lot of stuff, and it goes out there, and people remember that last week you liked this particular movie or you had this particular dispute. I certainly personally have learned more about my wife's friends and some of the things that they've been up to than I would have known, if it wasn't for Facebook.
Right.
But there's so much information it's out there generally, not just Facebook. I think it goes the larger privacy picture that is out there, is that there is so much information out there these days. I certainly would agree with those that say if you don't want it to be found by anyone, that you don't put it online. And I certainly would agree with that. There are plenty of times, I'm pretty active on Twitter and Facebook and so forth, but I certainly try to keep Facebook much more personal than I would Twitter. But even then, there's plenty of things that I still wouldn't put up on Facebook, just because I don't necessarily want that to be searchable or knowable. But it's the larger, I think, interesting privacy issues there with the the general aggregation of what's out there that I think that this whole dispute with Facebook touches on, because it illuminates this larger issue. I think what's the social graph, just what is that social graph, and how public should that social graph about someone be?
Yes, and I always, when we're talking along these lines, love to mention this concept we've talked about on the show a few times before, of not thinking of it in terms of an expectation of privacy, but thinking of it in terms of an expectation of integrity of context.
Of control.
Exactly. You want to be able to you want to be free to say certain things when you want to say them in the appropriate context. And we always, I've mentioned this 2 or 3 times before. It was in one of the articles a few shows ago. You don't drink in church and you don't pray at the bar. I love that because it encapsulates so well what we're talking about here. It's the most fortunate set of circumstances for us would be if Facebook would set itself up so that you can rest assured that the prayers you offer up in the church of Facebook are not construed to be drinking at the. Wait, I got that backwards. The prayers that you would offer up at the bar of Facebook would not be construed as whatever. My metaphor totally broke down there, so I'll just stop right there.
No, it's a great one though, and I do think that that it is a question of control and expectations, and just making sure that you're not thwarting what people would reasonably expect to be going on with their data. And I think we're getting to the heart of the problem. What with all the shifts. Even though Facebook is good about giving notice and, making you go through recently when they went through these changes, you got a pop-up and had to go through and adjust things, or, you got it back a few days later if you opted to delay doing it. And finally it made you do it, because I delayed and delayed and delayed. And then finally I could no longer, navigate around until I went through and did those connections settings. So they made you go through the process and think about it, but still, I think that it's a little much for people to be expected to understand and to think through all the ramifications of. Now you mentioned the Chris Perello article, and he was citing Robert Scoble. And Larry Dignan had a good piece over on ZDNet too. They're all in our show notes, and I should mention where folks can find those, because we always reference them. And then people after the show ask me, and you talked about the show notes, but where are they? They are in Delicious. This one is delicious.com/thisweekinlaw/59. And when you go to the twit.tv/TWiL page, our homepage for the show, each episode's show notes are always linked there. Anyway, their take on this is, it's an evolution. You can't expect a site to adhere to its original principles, and if they're going to change, they just need give notice. And if you don't so much like what you see there, then get out, or do what you've been suggesting, Kevin and Evan, that if you really want things to be private, don't put them on the internet anywhere. Social networks, your blog, wherever it might happen to land. Just don't let it go there. So there's that position. But I think that is not taking into account that in today's fast-paced world, where people are using technology without necessarily thinking through all the ramifications of it, that we need to put it all on users. I think that there is a responsibility that sites have, and apparently I'm not alone in that, because some senators in Washington have gotten together, including Al Franken, and written a letter to Facebook and suggested that they make things more transparent for users and more under their control by making things expressly opt-in rather than opt-out. Marty, do you have any thoughts on whether that kind of a strategy will have an effect, or if there would need to be more involved to achieve a change?
I kind of like market-based solutions, because I think that senators are kind of going to be slow and get it wrong. As we were talking, I'm thinking what would really be good is a how-to video with screenshots that is distributed via YouTube called A Parent's Guide for How to Adjusting Privacy Settings on Facebook. I'm in favor of getting this information out about how doing our best to keep everyone informed about what you can see and what you can't see, and advice like if you really want to keep it private, don't put it on Facebook. I think that could solve the problem quickly and cheaply and won't have senators mucking about. This is without regard to my feelings of Al Franken, who I think is very, very funny.
He is. He's
right,
good
and
enough
he was
he's
joined
smart
by
enough.
Charles Schwimmer, Michael Bennett, Mark Begich, and of course Al Franken we mentioned, in imploring Facebook to take a closer look at its goal of creating open and transparent communities and ensuring its policies are sensitive to the personal biographical data of its users and providing them with full control over their personal information. One suggestion I've seen is that perhaps the control issue should be more on the user side, since it's a user consideration, and that maybe this is something that could be done technologically through a browser. Perhaps this was a suggestion on the VRM, the Vendor Relationship Management list this morning, that maybe there could be browser-based control for who gets what information. Kevin, what do you think of that kind of a notion? And do you think it's practical? Because who's going to use a browser other than, say, the big three?
I'm not really sure I understand what you mean by browser-based control. I mean, are they going to be able to log in and see what their information looks like from a third-party perspective?
No, I think it would be in the initial sharing of information layer. So you're signing up for people who are already members of Facebook or any other network. A browser wouldn't necessarily help, but I think the concept would be that when you initially have an interaction with a site, the browser would have all your information locally, and it would know what you have said can be shared and what can't, and would populate your profile accordingly. I think I'm merely
So you have like some sort of central store based on your own local drive of your personal information, and then you would have like a profile. Then you would share that profile with Facebook, if I'm understanding that correctly. Mm-hmm. I certainly see issues with that from electronic privacy standpoint, from a electronic discovery standpoint. There's certainly, people could, be served with a subpoena to turn that information over, especially if you've got like a master profile that you've decided that Facebook only sees this section of it and Twitter sees this other section of your social graph. And I think that certainly would be an issue. It comes down to, I think, to a related idea would be like a national ID card. Something where you would swipe that's got all of your personal information in it, stored somewhere in the magnetic bar on the ID card, would serve a similar problem. And I for the same issues that I think that's a bad idea, I think storing that information locally on the drive is bad as well. Somebody steals your laptop, they've got your identity.
I think it's better to have it scattered in the cloud.
I don't know if it's necessarily better, but it's certainly less prone. If somebody comes in and takes your laptop, or if your hard drive fails, you don't lose your identity. Mm-hmm. You can reconstruct it.
Yes, excellent points.
Actually, it sounds like it's more scattered about the cloud than what we may have even realized. There's the good piece in the show notes that Kurt Opsahl wrote. The 6 things that you need to know about Facebook connections. And number 4 was the most troublesome one to me, is that Facebook will continue to store and use your connections even after you delete them. And apparently that is not just the connections that Facebook holds on to after you delete them, but also content itself. There was another Gosh, there were so
Right.
many great articles. It was that
Zach Whitaker.
Yeah, I was getting ready to say that kid over in England, and I don't feel bad saying that because they describe him as the youngest of the ZD network, right, or something like that.
Right.
That student over in Kent in the UK wrote the article about where, and he actually empirically proved this by uploading a photo of a kitten and saving the direct path to it, and then deleting it, and then finding it was still available several months later. So that it underscores the concern that we have about this data being strewn out there or scattered about the cloud. That problem is underscored by what could be this thing of even another step removed from user control. Even if you're trying to control it, Facebook in a certain sense maybe disregarding that, which would seem to militate against it being out there in this content distribution network, and would make a browser-based or local side control that you were describing a moment ago much more attractive from a user standpoint. It would seem to me.
Right. Between all the discussion around the privacy settings, the post from Zach, which resurrected a problem that's been noted before, that deleted information does persist in the data management infrastructure that Facebook uses, those persistent URLs that may not be publicized, but they're there, So if it somehow got out, that your deletion doesn't make it go away. And also this chat leak that they had this week, where Kevin, why don't you tell us what happened there?
My understanding of it is that for a short period of time, you were able to see not only your chats, but also your friends of friends chats as well. I think it went that far. I'm not sure if it was just your friends or friends of friends. You were able to see their chat history. You were able to see their chats. It's not that far different from what's happened with Google, with the Google Docs. All of a sudden, you're able to see everybody's docs that was shared, not just the private ones. These sorts of things are prone to happen with networked based servers. Somebody changes, for example, in a Unix permission, changes a 1 to a 0, and boom, it changes a whole bunch of other privacy settings that they probably never intended.
Right. So that's a bit different than having a setting that can be toggled that people may or may not have trouble understanding. This was an actual technical glitch that was
a
corrected
glitch
as soon as possible. But still, with the volume of information and the type that goes through the site, their responsibility to me seems very high to safeguard against those sorts of glitches.
Yeah. And
go ahead, Kevo.
I was just going to say, it was just that's something that Facebook. I'm sure they've got iron-tight protection for that in their terms of service. That they're not liable for those glitches. You sort of acknowledge that that's one of the risks for that information out there. If it should happen to be shared that way, that they're not liable. I don't know what else you were going to say, Evan.
This reminds me of something that James Grimmelman said, and when I heard him speak at a conference a few months ago, when we're talking about these companies that have these huge sets of data out there. And I'm looking in Wikipedia to get what I wanted to talk about here. But he compared, these companies like Google and Facebook and others, Amazon, whomever else, that may have these huge set of data. He compared it to the old tort case that we all read in the first week of law school, Rylands versus Fletcher. And that was, I just looked it up on Wikipedia here, is an old English tort law case from 1868. But it was the one that imposed strict liability for the landowner because they had this huge, I remember they had a huge body of water and a dam broke and flooded the adjacent land or something like that. I mean, when something like that happens in the digital context, or something like what happened here with Facebook is a little bit like that in the digital context. There's this
the chat dam broke.
Yes, there's this trust that we have in Facebook that they're going to keep these data secure and not let it be out there and to populate each individual's database of ruin, to use Professor Ohm's term. So, there's a good argument to be made, just like there was in Rylands versus Fletcher back in 1868, that notwithstanding any kind of contractual limitation of liability that Facebook would try to put in place here, they should be strictly liable for these bad things that happen. Now, I don't mean to advocate for that position necessarily, but I thought it's an interesting way of thinking about it and making a very apt comparison to something that happened in quite a different context.
Yeah, I agree with you and think that is a good comparison. It seems like beyond just writing to Facebook, there is more afoot in Washington on these fronts because, let's see here, Representative Boucher has released draft legislation that would require an opt-in rather than an opt-out strategy for sensitive online data and the sharing of that data. So that is now pending in the legislature, federal privacy legislation that specifically addresses user control over information. Marty, what do you think of this? Is this the kind of thing that this sort of bill could actually have an impact, or are you sort of skeptical that this will ever make it to a vote?
I'm very reluctant to ever discuss pending legislation. It just changes too much. It's just, I don't think it's a percentage move.
Yeah, and even the folks that you think would be most behind this, consumer protection groups, the EFF, have come in and said, it's nice that you're thinking about this, but it doesn't go far enough, and we need better default rules of the road for how privacy occurs on the internet, so you don't have to worry about opting out. The senior staff technologist, Peter Eckersley at the EFF, says here about the pending bill. So, Kevin, any thoughts about whether legislation is the solution, since we addressed a possible technical solution that has its own share of problems?
I certainly think that legislation may be an avenue to explore. I certainly think that there should be general obligations for sites, not just Facebook specifically, but all sites, to keep, their information. They certainly should have a certain level of standards that they need to have in their particular systems. Now, whether or not that's something that should be legislated, or whether just is in essence have community standards that come up because people that are in the industry will adopt a certain standard because it works best and it's the best way to protect things, or whether we need to set the standard for them to live up to. I think that's where you're going with that question, and I think that they certainly could, put forth those sorts of standards, and I think that would be fine. Now, who would enforce them? That would, lead up to, some of the other topics we had in our show notes. For example, a discussion I know you folks had last week on the ACTA and, the FTC and so forth. There's certain limits on their power.
Right, and that's the thing that concerned me most about reading about this legislation here is a concern that I think it was the folks from Yahoo had about what effect a federal framework for handling this would have on the individual states, both the common law causes of action and also any statutory causes of action. I would want to make sure, I don't know if I've thought this through a lot, but it would seem to be the better course that the legislation would not preempt the various states' laws for this and undo kind of the rich common law that the various states have undertaken for the privacy torts and things like that. So, but then the first cousin to that question is what would be the status of a private cause of action versus the government undertaking the enforcement of this legislative framework. So that's my concern about it.
Right. There's a funny quote here in this PC Magazine piece on the legislation where Representative Boucher is talking about the reasons for the bill and how they want to encourage greater levels of e-commerce, keep the wheels in motion, as it were, and while assuring users that their experience will be secure, and the greater sense of privacy protection will be particularly important in encouraging the trend toward the cloud computing. Hopefully he was misquoted on that, but yes,
you
the
found that
internet
on the Google, right?
And yes, the cloud computing. Who knows? Definitely for people to be able to trust the cloud, we do need some sort of either technical solution to this or legal solution to this. I don't know that leaving it to the marketplace is working so well right now. Marty, do you see? Explain to us how you think that might work itself out.
Well, I'm not a complete laissez-faire capitalist with this regard. What I'm saying is that I just am skeptical of grandstanding politicians talking about privacy. That means I'm obviously in favor of well thought out case law and statutes. I just don't think that open letters to Facebook is really the way to go. But I also think that a lot can be done through consumer education, as it were. That's what I'm referring to as marketplace solutions, really.
Mm-hmm. Yeah. But who would be responsible for that consumer education? I mean, if there's no requirement that you provide that kind of education, is this something that's just going to bubble up from the community, or how do you think it will play out?
Well, the specific thing that we were talking about, or my particular bee in my bonnet, had to do with Facebook not being usable and really communicating the privacy settings. So then there'll have to be some sort of relationship with Facebook, complaining to them, saying, listen, we want to know how to work this better. This is not working out. It's not clear to us how to make these settings. Bad things are happening. So Facebook presumably wants to, continue having a good reputation and having happy people and not having them go over to smaller, more secure social networks. So that's part of the market working. And my solution is that I think TWiL should do it as an advertising thing. They should have this guide as to how to set your policy. That was one particular aspect of consumer education.
What about a tax break for those who would undertake the efforts to do this education?
Oh,
you can deduct all the costs.
Absolutely. It's a promotional expense, so clearly it would be tax deductible.
Mm-hmm. Well, I think those are great ideas, and I'd like to see some of them put into place. But as long as we're on the subject of the cloud computing, I wanted to flag for folks, because I think it's interesting beyond just the legal world, that a formal ethics opinion was issued by the State Bar of North Carolina middle of last month about software as a service and lawyers using the cloud, which is something that that lawyers themselves and the ethical bodies that govern them have been concerned about for security and privacy reasons. Obviously, lawyers have a very heightened responsibility to keep their confidential information confidential, and yet that always struggles against the need to be fast and available and efficient and make full exploitive use of every possible technological aid in a client's cause. So a lot of lawyers have delved headlong into a cloud computing kind of world and have left these ethical bodies sort of wondering whether that's a good idea or not, and if it violates their responsibilities in certain instances. And what the State Bar Ethics Committee in North Carolina has done is come out and said, cloud services have their risks, but those risks can be managed. And it came out with a bunch of questions that lawyers should ask themselves before they go ahead and commit information to the cloud. And I thought, sort of a best practices approach that has to do with, okay, so what do you know about the integrity of the particular service you're using, and what sort of safeguards are there, and basically kind of a common sense approach to using these services. And if those steps have been gone through, then there's no ethical violation. Do you guys have any? The reason I bring it up in a show that is about technology law in general is because if lawyers can do it, then presumably others can too. So, Kevin, what do you think about this?
Well, one of my side gigs, I'm currently the vice chair of the Chicago Bar Association's Law Practice Management and Technology Committee. So I certainly have been, watching and, waiting for this particular opinion to come out for a while. I think lawyers are usually like some of the later adopters of particular technologies. People have been doing cloud computing for years in other industries. And it's, but we as lawyers have other obligations, such as confidentiality and so forth, that really aren't there in certain other industries. And so I think it's really good that a forward-thinking bar, such as North Carolina, has come forward with an ethics opinion that's not mired in the late 1990s in terms of analyzing the technology and analyzing the risk. In which they acknowledge these certain practicalities that lawyers are going to be using these services. I know at ABA Tech Show I talked to a bunch of different vendors such as Rocket Matter and the people Clio, Jack. I forget his name exactly, but the people at Clio and Rocket Matter certainly, that they're hinging their business on providing these cloud services to lawyers, and people need to be able to trust that their data is going to be protected, and I think it's a good thing. It puts the burden back on the lawyer to analyze and choose between a particular vendor over another by looking at it and saying, this particular vendor meets the requirements for you because they are secure, they encrypt at the proper level, they've got the proper level of backup. They've got a geographically distinct backup, so if Katrina happens and it wipes out your home and your office, you're not out of luck. So I think that's a good it's a good guideline, I think, for other bars when they look at this issue, because this particular ethics opinion will only affect directly lawyers in North Carolina, but a lot of other bars, when they do look at it, will look favorably on an ethics opinion from another jurisdiction that's actually addressed this particular issue. So I think it's a good step towards acknowledging these realities, as I mentioned earlier, that all these other industries are using cloud computing, and it's time for us as lawyers to go forth and do so responsibly.
Evan, someone in the chat room has said that lawyers should never use cloud computing. Do you agree with that? And what do you think of North Carolina's compromise on the point?
I think the North Carolina opinion is very well written. It's very well principled. It starts off with a succinct, wonderfully accurate description of what cloud computing technology is. So I think that the opinion is well reasoned, and I think it comes to the right conclusion, and it's said in an appropriate way, namely that you can use software as a service if reasonable care is taken to effectively minimize those risks. And it even goes on to not only has that belt there, but it also has some suspenders for us as well. It says, however, the law firm is not required to guarantee that the system will be invulnerable to unauthorized access. So, it opens the door for it. Now, it wouldn't be too difficult, and I think that a person could say it with a reasonably straight face. You could make the argument as to why lawyers should not use cloud computing technologies, because there really is no way to be 100% assured, even if there are contractual obligations on the cloud provider to keep the stuff confidential and secure. You just really don't know what's happening to that data if it's on a server somewhere in the Silicon Valley and you're practicing in Omaha. So that is the point on which one could hang an argument or the foundation upon which one could build an argument is that notwithstanding all the promises in the world and notwithstanding all the due diligence that you can do on the cloud provider, and the second part of this North Carolina ethics opinion actually to me is the most valuable part, because it's a roadmap for doing due diligence on a cloud provider, and I plan on using these principles not just in evaluating. Nobody here at my firm is asking me to evaluate any cloud services that we're doing. There are people who have that well taken care of. But, certainly I get the question posed to me from clients all the time, non-law firm clients. I'm thinking of using this service for, whatever function. It's obviously based in the cloud. Should I rely on it? These types of guidelines that are in here are very useful for making that analysis. I think that it's just we're just beyond the tipping point now. We're too far gone, if you want to say it that way. We're too far beyond the point to say that lawyers shall not use cloud computing services, though there are principled arguments that one could make against it. Just like there are principled arguments that you could make that you should never leave the house in the morning for fear of, you name it, getting skin cancer, getting hit by a bus, whatever.
Yeah, but I think there's some different valid concerns that some of these people have about using cloud computing. And I agree with them that there are serious concerns. But for those people that want to do it, I think this provides a roadmap for doing it responsibly. One of the major differences that I've heard and problems is that for example, when your data is stored on a server in your office, it will require a warrant for someone to come in and get it. If your data is stored on a cloud computing service, all it's going to take is a subpoena.
Yeah.
Right. Which is something we were talking about last week and before with regard to Jason Chen and the information that was on his computers and...
Not much happening on that case, is there, this week?
Yeah, no, you're still safe. You're not wearing your Saints jersey, and you don't need to be as far as your bet went. So we'll see.
Imagine that.
Ernie sends his regrets, by the way. He had some other obligations this week, and I think he's also out next week, but I'm looking forward to touching base with him again soon.
Right, yeah. Whatever.
Now, does Ernie have to wear anything, Evan, if you should win this particular bet? I don't recall all the details.
No, I am just so confident it doesn't. I don't want to put Ernie in a tight spot.
The details for anybody who didn't listen to our previous shows was that if Jason Chen or Gizmodo wind up getting charged with any actual criminal charges, then Evan's or
if anybody files a civil suit, if there's any legal action whatsoever,
any legal action whatsoever
at any time in the future,
then Evan's going to wear a New Orleans Saint jersey, which I imagine is quite a sacrifice.
It would be quite offensive to me, yes, to have to do that.
Okay.
Yeah. Well, I know you folks have covered this quite thoroughly in other shows, but my personal take is much more on the lines of the John Gruber analysis. That Gizmodo was playing with fire when they paid $5,000 for this. So whatever the consequences may be, they certainly bought them.
Right. That really is indicative of what they should have known about the provenance of the device if they're going to pay $5,000 for it.
Right.
Yep. Hey, Marty, I had a quick question for you on this cloud computing point, because the person who tipped me to the North Carolina ethics opinion thought that there might have been something completely on the opposite end of the spectrum that came out of New Jersey, but then didn't have any more information. And I certainly have not done a 50-state survey of each bar's ethics committee's take on cloud computing. Does the New Jersey thing ring a bell with you, or do you know what your neck of the woods in New York thinks about all this?
What's New Jersey?
You're closer geographically, so you'd have to tell me.
The New York State Bar was too busy hassling us trying to regulate blogs and then being reversed on that. I apologize. I would have looked it up if I had advance notice.
Yeah, sorry.
But I do want to add my 2 cents about cloud computing. 2 thoughts came while listening to Evan and Kevin, and that is I'm reminded of being on the technology adoption committee of my law firm during the mid-'90s. And there were some cautious, or I would call fearful people who would say, well, if we use email, then this will happen. And if we have a network, then that will happen. And my normal rebuttal to that was to identify risks that they were already enduring using regular mail and pencil and paper. So I guess I'm somewhat in agreement with Evan's comment about those risks leaving the house in the morning. That's not to say that there aren't differences and new vulnerabilities and that careful adoption is called for. But, prudence has to overcome fear. The other thought was that when I started my own practice in 2001 is that if I had not been able to use web-based trademark management software and web-based accounting software, then I don't think I would have been able to open my own practice or at least run it without significant clerical help. So it does some good, this cloud computing thing.
There you are being an economist again. That's wonderful.
It is my bent.
All right. Well, we talked a lot about privacy in connection with Facebook. We talked somewhat about subpoenas in connection with where you store your data. So let's talk about this Arista case out of the Second Circuit, which melds both of those considerations. This is a classic case by a record label against unidentified Doe defendants who were allegedly using file sharing technology to illegally download pirate copyrighted material. There was, as there frequently is in these cases, a back and forth with the judge about the identities of the defendants. What happens is that someone will file a lawsuit like this, not knowing the actual names of any of the defendants, simply perhaps their IP addresses and who their ISP is, however they gather this information about P2P traffic. Then they go to the court and they subpoena the information from the ISP. And folks on the other side who know that this case may come after them personally have the opportunity to object to that through a motion to quash the subpoena, make the subpoena go away and try and protect their information from disclosure. And what happened in this case, just out, decided April 29th, 2010, is the motion to quash was denied, and the ISP was made to turn over the information about the Doe defendants so that they can be sued in their own name and the lawsuit can gallop forward. Did this case surprise anybody? There was some interesting language in here about free speech and whether the First Amendment would provide any shield to your activities and your information that is held by the ISP. And the court decided that the First Amendment was actually no protection when copyright infringement was the allegation, and actually didn't couch it quite that way. The court used somewhat sort of disturbing language that seemed to assume that infringement had already somehow been demonstrated, even though they're right at the beginning of the case. But be that as it may, it didn't buy the First Amendment argument and went ahead and ordered compliance with the subpoena. Kevin, any thoughts on this one?
Well, I'm not sure what the standard is from the Second Circuit, other than from reading this particular case. I can tell you that I personally have helped the EFF file an amicus brief in a local case here dealing with anonymous speech, and but that was a much more different kind of case. That one was defamation, in which case there certainly are First Amendment rights that would be implicated in political speech. Here it's just copyright infringement, and you really aren't making a statement against the man by file sharing. You're not by pressing the upload button or putting thing in your upload directory on BitTorrent, isn't an act of speech per se. It is a statement, but whether it's speech is another matter. And whether it's wise is another matter too. But certainly, these sorts of cases have been litigated for a long time. I know, the RAAA, routinely brings these, cases to get the identities of ISPs, content people, and getting their IP addresses so they can be sued. Actually turning their IP addresses into actual people. I've certainly helped people that have been on the receiving ends of those lawsuits, and it's quite routine as long as they're able to meet the standards, for requiring the turnover of that information.
Yeah, the exact quote from the court here is the First Amendment does not provide a license for copyright infringement, from Judge Amalia Curse.
And that would seem to me to suggest that, the court's not really trampling on the First Amendment here or saying that it doesn't apply. It's just that, given these circumstances here, of course, they were just looking at the pleadings and, in an exhibit that was attached to the complaint here. The question is the strength of the allegations in the complaint and how likely it is that infringement really has happened here, which should occasion the anonymous defendant to be identified. And we, of course, as Kevin has mentioned, we see this scenario or this balancing of interests here, or this alignment of interests in defamation cases pretty often, and we've talked about that before. To me, the situation in copyright is a little bit different because of the way that the prima facie case is alleged. In defamation claims, we've of course got to allege facts that will say that establish that a statement was made about a person that's harmful to their reputation. It's all very dependent on how the pleadings are actually couched, and most of the times this is in state court. And state courts, many state courts, I know Illinois is one of them, require fact pleading, which is a heightened pleading standard, higher than what there is in federal court, even after Twombly and Iqbal, which the court talks about here in this federal case. Federal pleading is just notice pleading. So right there, we're looking at not always as high of a standard. But one of the critical ways that a copyright cause of action is pleaded differently than a defamation cause of action is pleaded is in the import and the significance of the registration certificate. And I don't think this Arista Records case from the Second Circuit ever talks about this, but it would seem to me something that underlies the notion of the strength of the case. The effect of a copyright registration is to essentially establish half of the prima facie case for infringement. That is the ownership of a valid copyright. Now, of course, you can challenge what the Copyright Office said about your work or about the plaintiff's work, whether or not truly is copyrightable. That's something that the judge can review. But just by going into court and showing the judge or pleading this in your complaint that you have a registration does a lot more than anything you could ever do in pleading a cause of action for defamation. So that fact there, or that way that things are, in addition to just being in federal court with notice pleading standards, seems to make it much more likely that the anonymous defendant is going to be unmasked, just as it was here shall be in this decision here. So I don't think one final point is I think that this probably wasn't the best case for the defendants to make this argument, because it sounds like there was a lot of factual matter in the complaint, notwithstanding notice pleading standards, to demonstrate that infringement had really occurred. So as Ernie likes to say, bad facts make bad law. And this might have been one of those things where just bad facts give us a outcome that the defendant didn't like.
Yeah, I think it's worth mentioning the distinction that was argued in this case, not that there was a First Amendment speech protection to whatever information might reside on the server, but as you referenced just a minute ago, Evan, a First Amendment anonymity protection, which I think is an interesting concept to throw out there. Marty, this one was in your neck of the woods. Any thoughts on it before we move on?
I was all prepared to say bad facts make bad law in the run-up to this. I mean, and the reason is that, first off, I agree with Evan's distinction that they're relying on the notice, the specificity of the pleading, and I can postulate some troubling fact patterns in a copyright context. So the court said, we're going to balance the modest First Amendment right to remain anonymous versus the copyright owner's right to learning the identity of someone who's violating its rights. And I do notice that they did not hedge in the way that you did, and that learning the identity of someone whom it's going to allege is violating its rights. And one of the more troubling sentences in the decision is that allowing strangers to have access to your information renders void any pretext of privacy. And I think that if we're talking about someone who downloads this commercial music, which is what the defendant here allegedly did, and allows anyone in the world to access it, okay, that sentence is grammatically correct, and it also might be not offensive. Allowing strangers, any old stranger, to access your information on the internet renders void any pretext of privacy. How about this fact pattern? Let's assume that there is some organization that refers to itself as a religion. Perhaps it's founded by a science fiction novelist. I'm going way off base here to come up with these facts. But let's assume that the tractates of this religion are copyrightable, and somebody wishes to expose this or have political speech about this organization, and to do so needs to copy these copyrighted tractates. And then they're going to allow any old stranger to have access to this information. I think that a plaintiff in that case can show a very valid copyright registration, and they say, we have this amazing right to disclose, to have disclosed to us the identity of the trespasser, and we think that our property right outweighs the modest First Amendment right to remain anonymous. So I think that is a copyright fact pattern that I don't think is science fiction, and that is what worries me about this case.
So let's stick on music for a bit as we wind down toward the end of the show here. Did you guys see that Apple killed Lala?
Yes.
First bought Lala, then killed Lala, which struck me as incredibly, well, perhaps incredibly short-sighted, but I guess it all depends on what Apple intends to do in iTunes. Because my take on where this is all going is I've been a huge iTunes user and fan for years now, since it first became available. And I'm starting to feel like it's not where folks are going with their music. And Robert Scoble had a good post on this as far as traveling in other countries and not being able to access what he wanted to access because certain services are blocked. Bob Lefsetz had a great quote from Peter Sunday Kolmisapi. Hope I haven't butchered that too badly. One of the four founders of Pirate Bay, who said, "The problem with music today is not how much is one song. We have so much we can't choose from it. Maybe I should get paid to listen to one song. There are so many things that's wrong with today's model and needs to change." And one of the things I think first and foremost is, we don't really have the ability to be anywhere we are and have instant, spontaneous access to our music collections with whatever device we have on hand. iTunes doesn't do that. The streaming services do it better, and that's why the Lala thing is distressing to me, and I wonder if it's what it means, whether Apple's going to use the technology somehow or just not offer that sort of a service. Kevin, any thoughts on the future of the music business model?
Well, I certainly agree that it's in trouble. I think there's plenty of online music services such as Lala used to be, but Pandora and some of the others are certainly seem to be doing okay. Whether that's a viable business model is another matter. I personally think there's going to be some sort of streaming service coming out of Apple, which is why they killed Lala. There's something that they want to get those engineers involved with. Sometimes Apple buys things not necessarily for the product, but to get to the people. And I think that certainly is something that people might want to keep in mind is, that they bought the company so, that expertise can be used for something internally. So other than that, I think in general, it's definitely a troubled industry. Where it all shakes out in 5-10 years, who knows?
Evan, any predictions? What's the future of music? Is iTunes a dinosaur?
Probably, because we're moving away from the individualized nature of the work. One track. 5 years ago, 10 years ago, at the beginning of the Napster era, it was revolutionary to think of a piece of music as a file. That was revolutionary. It was revolutionary before that to think of music as digital, on a compact disc. But what we're moving away from is the notion of music as a tangible commodity, or even any way separable into units in the way that a digital file is. A digital file is more like a vinyl record than what it is a downloaded MP3 file, let me clarify, is more like a vinyl record than music that is available through a streaming kind of service. So Lefsetz is right. He's been talking about this for quite some time. We've got, for the music industry to be viable and to meet the tastes of the consumers and the desires, the predilections, the way they want to consume content, it's got to go to more of the way that cable television is going, where you pay for access. And that is healthier for everybody, including those of us who are concerned about how copyright law should be administered as well, more of an access-based thing. As for Lala, I'm confused as to why Apple is just shutting it down if they want to, use that technology for something else. It would seem like they would want to make a smoother transition rather than just pushing everyone away on May 31st. So I'm nonplussed about what they're doing here. But people a lot smarter than I am are making those kinds of decisions.
Right. Hey, Marty, does the music industry have to change its business model? We have a piece in our show notes from Nate Anderson at Ars Technica that the music industry, despite all its piracy protestations, grew in 13 markets in 2009. What do you think?
That's a little bit surprising. I was just going to note in passing that my 14-year-old has never purchased a CD in his life, which makes me feel old. And that he informed me recently that he no longer really uploads any money to iTunes. He only listens to sites I've never heard of, and I follow the industry. So that makes me feel dead.
Well, on that note, we're going to wrap so that we can make way for the next show here on the network, which is Futures in Biotech. We thank you so much for joining us here on episode 59 of This Week in Law. And specifically, Kevin Thompson, great to have you on the show.
Well, thank you, Denise. It's pleasant to be here.
It's really been a pleasure. We appreciate your insights. Folks, go follow Kevin on Twitter at Cyberlaw. Great Twitter handle, by the way.
Thank you.
And at cyberlawcentral.com is Kevin's blog. Marty, wonderful to have you back on the show, too.
Thank you, Denise. And just to tie into this business about how we have different social networks in our life. Earlier in the show, you said my Twitter handle was at @mschwimmer, which is really, I try to make a personal Twitter thing where I talk about my family and what the weather is like. The social network for professional things is at Trademark Blog.
Ah, there we go, at Trademark Blog or at @mschwimmer if you want to hear more about Marty's golden retriever, etc. And schwimmerlegal.com is where you can find out all about the latest and greatest developments in trademark law, which Marty is very good about getting out there to the world. So thanks so much for joining us.
Very good.
And Evan Brown, internetcases.com, Evan's blog, at Internet Cases on Twitter. no demarcation there.
Nope, it's just all me. But this has been a great conversation. It's been real fun hanging out with you, Kevin. We're old friends, and also really need to have a conversation with you, Denise, and with Marty. Of course, I remember first being introduced to the concept of law blogging way back in 2003 when I read that article in the ABA Journal. Then there was Denise Howell and Marty Schwimmer, among others, who were these very prescient thinkers. And so took another year or so for me to get into the blogging mode after that. But very cool to be having this conversation. I've really had a great time.
Thank you. And with that, we will see you folks next week live at 11 on Friday. Take care.
See ya.
Bye now.